guys? It's Brandon L. Stevens of Brandon L. Stevens Law PLLC, and today we're going to be talking about some of the potential U.S. copyright and trademark implications for Nintendo in their ongoing dispute with Palworld. Now, I've covered the patent side of things in another video, and I invite you to check that out. Copyright doesn't protect things like game mechanics that were in dispute with the patents. Instead, it protects artistic expression, things like creature designs, music, and storylines. The question for copyright infringement analysis is, for example, are Palworld's creature designs substantially similar to Pokemon's? Let's look at some of the comparisons. Some pals look close, others don't. What do you think? Copy or coincidence? Comment below. Now, for the trademark side of things, trademarks protect branding, things like names, logos, and distinctive symbols. Nintendo owns the Pokemon name in the iconic Pokeball trade dress. Palworld avoids that name, but its Pal's spear does resemble a Pokeball somewhat. Here, the legal test is there a substantial likelihood of consumer confusion? In other words, would US players think that Palworld is somehow connected to the Pokemon franchise? Nintendo would presumably argue yes, and Palworld would argue the changes are enough to avoid a substantial likelihood of consumer confusion. And that's where a US court battle could center. So to be clear, in the US, the real questions could be, 1, are the creature designs substantially similar? And 2, does the PAL spear cause a substantial likelihood of consumer confusion? I'm Brandon L. Stevens of Brandon L. Stevens Law PLLC. If you want more breakdowns of real-world IP battles, subscribe here at BLSL_PLLC. I have an Instagram handle of the same name, and or visit BrandonLStevensLaw.com.